So, good evening, everyone. My name is Makesh Giri. I'm the Secretary of Tennessee Tamizh Sangam. On behalf of Tennessee Tamizh Sangam, I welcome you all for our very first immigration webinar hosted by us. I also want to thank FETNA and their leadership for partnering with us and supporting us on this initiative. So, we all are in this great country in pursuit of something. It could be better opportunities, lifestyle, education. While it may seem like getting into the country is the battle half won, many of us don't realize that until we get started on the actual immigration process, nothing really has started. So we hear many stories about visa rejections, families torn apart, financial loss, deportation due to lack of maintaining appropriate legal immigration status. We have to understand and appreciate that there are experts in this field of immigration whose daily job is to ensure that legal immigrants like us are taken care of. So I got associated with Sumner Immigration Law in 2012, and they've helped me and my family go through the process. Emily and I have had a 11, wow, it's been 11 years, Emily, 11-year friendship and professional relationship, and I feel very comfortable and confident in her abilities in the area of immigration law. So with that, I would like to hand the mic over to Emily Sumner, who's the founding attorney of Sumner Immigration Law. Emily, take us away.
Thank you so much, Magesh. I appreciate it. As Magesh said, he and I have known each other for a while, and a long while, and I especially appreciate knowing him, and I just associate starting to work with him when I started my practice. I was an associate attorney at a small law firm for about 6 years, and then I went out on my own without knowing if I would have any clients at all. And he was associated with a company at the time that was one of our very first corporate clients. So I appreciate all of that support over the years, and I'm glad to be here. As Magesh said, I am an immigration attorney. We are based in Richmond, Virginia, but I was telling Magesh, we have this wonderful office, and I'm muting everyone right now. We have this wonderful office space, and we all work from home thanks to COVID. And I realized thanks to COVID that we do not have to have people actually in the office. Before COVID, I thought, oh my goodness, I need everybody in the office because we submit everything to USCIS by paper. There are a few form types that we can submit online, but it's not a great experience, so we rarely do it. So I thought I need everybody in the office. And then with COVID, I realized that I can make it work to have people outside of the office. I had to. And now I'm able to hire amazing talent all over the country. So we have 3 of us in Richmond, 1 of us in Texas, 1 in New Jersey, 1 in Massachusetts, and 1 in South Africa. So we are going to go ahead and get this show on the road. One caveat is that none of this information is legal advice. I can't provide legal advice to you all, unfortunately, in this forum. I'm happy to have a consultation with you. If you have specific questions after, we can set that up for after this meeting. The other thing to keep in mind is this is super high level. You may come away from this. There may be some things that you think, okay, I already know that, Emily, or you may come away from this thinking, oh my goodness, I have more questions than when we actually started. And either way is totally fine. I want this to be, this is for you. So I want this to be informative and helpful for you. So we're going to show you what we're going to talk about in then just a minute, and then I want to ask you a question. So like I said, we're based in Richmond, Virginia. We handle primarily employment-based immigration, some family-based immigration. So I would say about 80 to 90% of our practice is employment-based. Within employment-based, we handle almost all types of employment-based cases, of course, lots of H-1Bs, and then the other letters as well. So for example, E's and TNs and H-1B1s and O's, R's for religious workers, that type of thing. We also handle family-based immigration, so we help clients who either fall in love with a foreign national and want to bring them to the United States, or who want to sponsor family members who may be overseas, and helping families reunite here in the United States, as Magesh was saying. Our client base ranges all over the place in terms of industry. We have a lot in IT, especially in IT consulting. We also have a number in pharmaceutical development and financial tech, other technology sectors as well. Healthcare technology is a huge area, and we have several clients in that area. vets, meaning veterinarians, people who help animals as well. So we're happy to help people from a diverse range of industries. And I think that's a really interesting aspect to my job, to learn about all the interesting and amazing things that you all do professionally. So with that, this is what we're going to talk about tonight. We're going to talk about job movement for skilled personnel between jobs if you are on H-1B or L. We will talk about options beyond the H-1B lottery, qualifying for a green card outside of the more traditional PERM process, EB2 or EB3, options for entrepreneurs, visa stamping in the United States. We'll talk about that. I know that's an exciting topic, but we'll see when that happens. Options for aging parents, and then I will definitely leave time for questions and answers. So with that being said, I have a poll, and I've never done a poll before. So let me know if you see this poll. The question is, what is the topic that you're most excited to learn about? Do you all see the poll? Okay, somebody does, because somebody's posted. So I'll give you a couple minutes to respond, or not minutes, but a few seconds to respond to that. But these are the options, and I want to know what you're most interested in, and we can kind of customize what we're talking about to spend more time there if you want to. While everybody's putting in your answers, my office manager and I, she helped me put this together and was great coordinating with Magesh, who set this up. And she said, Emily, I think the most popular answer is going to be the Q&A session at the end, but so far it's not. We'll give everyone a few more seconds. All right, so let's see what our results are. The results, can you all see the results? Yes, no? Like I said, I've never done this before. Top result is qualifying for a green card outside of EB2 or EB3. I can't imagine. Well, that's such interest. Just kidding. I know the priority dates are not looking good. So that is, okay, so Stanley, thank you for telling us that you can't see the results. I apologize. But the results, top 43% say qualifying for a green card outside of the EB2 or EB3 process. Options beyond the H-1B lottery, Barbara says you can see the results. Okay, great. It looks like the second, and then, yeah, okay. All right, well, let's get started. And I will try to spend some more time on those two particular topics. As we go through any of these topics, all of these topics, let me know if you have questions. Feel free to put them in the group chat here. I will unmute the mics at the end for the Q&A session, but as we're going through this, if you have questions, put them in the chat. And if it's something, I'll try to keep an eye on that. And if it's something that is relevant to what we're talking about then, I'll try to answer it then. If it's a complex fact pattern that's case specific or specific to you, I'm not going to be able to answer that. But if you have general questions, go ahead and put them in and we'll cover them as we go. So number one, job movement when you are on H-1B or L status. So we'll start with L. The L, as you probably know, is for individuals who are employees of multinational companies who have come to the United States on L1A, which is for managers or executives, or L1B, which is for specialized knowledge workers. The L is challenging. It can be challenging to move jobs because it's company specific. So unlike the H-1B that we'll talk about in a minute, you can't really change employers in the United States unless you qualify. It's possible that you still qualify for an L with a different company. But most often, if you're talking about changing jobs on an L, you're really talking about changing jobs from either within the same company, maybe getting a promotion, or changing to work for a different entity that's still related to the entity that you're working for. The change of status, let me move my chat box here. The change of status to the to H, I think that should say L1. If you file a change of status, it is possible to file a change of status from L to H-1B or vice versa. But it's, like I said, in terms of changing from company A to company B on the L, that's not something that happens often. Another consideration if you're on L, whether you're on L or H, another consideration is where you are in the green card process if you have started the green card process. With the L, there's a limit on the number of years, and the H, when the number of years that you can hold L status. It's 5 years for specialized knowledge workers, so for L1B, and 7 years for L1A. That's something to keep in mind because you cannot extend, unlike the H1B, you can't extend beyond that time frame, 5 or 7 years, even if you have an approved I-140. It's different from the H1B. So I do see fairly frequently individuals change status from L to H1B to be able to keep extending their status beyond the 6th year of H1B status. We'll talk about that in a minute. But just know in general that for Ls, it's hard in general to change jobs. It doesn't mean you can't, but you're probably going to end up, if you're leaving the company, you're probably going to end up changing to H1B. And if you do that, which is what we're talking about here, change of status to H1B, if you do that, you're probably going to be subject to the H1B lottery. The H1B, transferring jobs while you're on the H1B, is a lot. I don't like to use the word easy in the immigration context because it seems like nothing really is, but it is more straightforward with the H1B. You can file what's called an H1B transfer, or rather the new employer would. So if you're working at company A and you want to start working for company B can file an H1B transfer, which is a new petition, but it's not subject to the H1B cap. H1B portability means that you can begin working. It's a portion of the regulations that says that you can begin working with the new company as soon as USCIS receives that H1B petition, which is a really nice aspect. That does not apply to other visa types. So that's a really nice aspect. You can change status from to H1B from another classification. So we just talked about that from the L context. And you can also change status from H4 to H1B, for example. But one thing to keep in mind, and we'll talk about the H1B lottery in just a minute, but that's something to keep in mind, is the H1B cap. There's a limited number of new H1Bs available every year. Considerations to make if you're in H1B status now and you're thinking about changing jobs are, again, where are you in the green card process? I said a minute ago that for the L classification, there's a limit of 5 years or 7 years, depending on whether it's L1B or L1A. For H1B, there's a limit of 6 years. And time in L status counts against the 6 years of H1B status and vice versa. So anytime that you spend, and if you have been in L status, anytime spent in L counts against that 6 years. However, with the H1B, you can extend beyond the 6th year if you have an approved I-140 petition, or if you have filed the labor certification or the I-140 within more than at least 365 days before the end of the 6th year. I know that's a lot of information, but just know, bottom line is you can extend beyond the 6th year if you need to in H1B, whereas that's not true for the L. Another consideration in H1B movement, and this is something that we try to make sure to ask about because it's critical, is considering whether you're whether you are going from a cap exempt organization to a capped subject organization. So I talked a minute ago about the H1B cap, the annual numerical limit on the number of new H1Bs available every year. There are some organizations, primarily institutions of higher education, certain research organizations affiliated with the government, or certain nonprofits that are affiliated with institutions of higher education. Just know that there are some organizations that are cap exempt. If you are working for a cap exempt organization, you can't then just file an H1B transfer to go to a cap subject organization, or typical private employer. So that's something to be aware of. Let me know if you have questions on this. Options beyond the H1B lottery. So put in the chat if you've heard of the H1B lottery. I'm interested to know what you have heard about the H1B lottery, or what you know about the H1B lottery. Anyone? Has anyone heard of the H-1B lottery? It fills up fast. True story. What has anyone else heard? Yes, a lot. Does anyone know the limit on the number of new H-1B petitions available or new H-1Bs available every year? Lots of numbers. 85,000. Yes. So the winner here is Kai. The limit is 85,000, and you're right, Raj, too. It's and Barbara Flynn. It's 65,000 plus an additional 20,000 for U.S. master's degree holders, U.S. master's degrees or higher. So that's a total of 85,000. The 65 regular, what we call regular cap, and then the U.S. master's degree cap of 20,000. So any guesses? Yes, Jagan, that's correct. Any guesses as to how many H-1B registrations USCIS received this year, meaning in March of 2023? It was more than 85,000, I'll tell you that. So we have 200,000, 180,000, 750,000 is very close to the winner. Kaif, again, good job. So the amount was close to 800,000 registrations this year for the 85,000 slots. So as you can imagine, the selection rate was roughly 10%. That's not amazing for employers or employees who need the H-1B visa to be able to work in the United States. So a big topic that we talk about throughout the year with our clients is alternatives to the H-1B. Definitely it's worth registering because obviously 85,000 people, quote unquote, win the lottery. But it is a huge problem for the United States. It's something that needs to be addressed, but that number is set by the statute. So that means that that's something that Congress would have to change. I don't know if you've ever heard the phrase, it takes an act of Congress, meaning it's next to impossible to get done. But it's a big thing to change. So let's talk about alternatives, because the H-1B is not the only visa classification out there, not the only option out there. Whenever I'm talking to clients about options, alternatives to the H-1B, if I'm talking to an individual client or to an employer who's looking to employ a foreign national, I literally run through the alphabet in my head and then talk about different visa classifications and the possibilities, because there is, for almost every letter of the alphabet, there is a different visa classification and then sub-classifications within those. I'm not going to run through the alphabet with you right now, but here are some of the more commonly used alternatives. One is the O1 visa. Has anyone heard of the O1? Extraordinary ability. The O1, we'll talk in a few minutes about the EB1 classification for foreign nationals of extraordinary ability, and that's for the green card. The O1 is for individuals. O1 requires PhD, Shrikant says. That's a great question. And the answer is no, not necessarily. That's a common idea, a common thought that people have, is that it requires a PhD. And I think one of the reasons for that is because the criteria for the O1 are such that people who have a PhD, especially researchers, professors, people like that, more easily qualify for the O1 than a software developer, for example. I'm not saying a software developer couldn't get one, but it's the criteria lend themselves more easily towards that. So like I said, O1 is for individuals with of extraordinary ability or achievement. There's 6 regulatory criteria that you have to, and you have to show that you meet at least 3 of those criteria, or it might be 2. But you have to show that you meet those criteria. And it's things like showing that you've made a significant contribution of major importance to the field. Things like you've written scholarly articles. It's helpful if you can point to the number of citations that you have. It's helpful if you can point to any awards, national or international awards that you have made. It is available to individuals in a wide number of fields. We think about this. Somebody, I think it was Shrikant, said a minute ago that do you have to have a PhD to qualify? And the answer is no. We have had clients in a number of different fields, including like digital arts, for example, business, science, education, all qualify for the O1. And then there are other classifications as well for individuals, like movie makers and things like that. But the O1 is absolutely a possibility. It's hard to get. It's not available for everyone, for sure, but it's definitely worth looking at because it could be a possibility. The second option that we're going to talk about tonight as an alternative to the H-1B cap is cap exempt employers. So I said a few minutes ago that there are some organizations that are cap exempt. That means they're not subject to that H-1B lottery that we were talking about a few minutes ago. Cap exempt employers include universities or institutions of higher education, nonprofits that are affiliated with institutions of higher education, and certain government or certain research organizations, not all, but certain research organizations. I have used the H-1B cap exempt kind of strategy several times, numerous times for clients, especially where they work concurrently with a private employer, which is absolutely possible. So in other words, I have a client who's working for an H-1B cap exempt employer, let's say a university, and then they want to work part-time, full-time, whatever it is, with a cap subject employer. They can do that and not be subject to the H-1B cap as long as they're working at both places concurrently. Now, if they have an H-1B petition available if they have an H-1B petition for the cap exempt organization, for the cap subject organization, and then they stop working for the cap exempt organization, then they no longer can work for that cap exempt organization. You have to be working for the cap exempt organization to be able to continue doing that. But that's absolutely a possibility. One question is, what is the minimum number of citations required to be considered for the O1? And I'm smiling because there is no minimum number. You don't even have to have citations, but it really depends on your particular field and what's relevant for your field. So for example, if you are let's say a digital artist, for example, you're probably not going to have citations. That's not really a thing that they do. But if you're a digital artist and you're able to show that you won these national or international awards, that would fulfill one of the criteria that you have to show, or criterion that you have to show. So it depends on your field. And I actually we'll talk about this towards the end of this webinar, but I actually did a YouTube show recently that just dropped today on LinkedIn. And at the end, we'll have a QR code that will take you to that. But I actually answer that exact question in more detail. We talk about it in the EV1 context, but it is relevant to the O1 context as well. So that interview has a lot more details on that. You could continue on OPT. So depending on what your current immigration status is, when you register for the H-1B lottery, you could continue on whatever your current status is. So every year we have people who are registering who are on OPT, who are on H-4 EAD or L-2 EAD, and for whatever reason, they want their own H-1B, totally fine. But if it doesn't work out, you could continue on that. One thing that a lot of people ask about is CPT, especially day one CPT. That's something to be careful of. CPT stands for curricular practical training, and it is designed for individuals who are in a course of study. You have to be on F1, which is the student visa. It's designed for individuals who are taking a course of study that requires some sort of hands-on experience. So an internship, an externship, some sort of hands-on experience, and that's what CPT is designed for. It is not designed to be a substitute for the H-1B, and there are some universities who will have a very loose interpretation of the regulations and issue day one CPT on a regular basis. And USCIS is aware of that, and they may issue a request for evidence asking for extensive documentation to show that you're actually maintaining your F1 status. So if you do day one CPT, just make sure that you're aware of that risk and make sure that you're still adhering to the regulations, the F1 regulations. You're still going to classes and Able to show that you have syllabi and that you're paying for textbooks, if that's the thing people still do. I think you get them digitally. I don't know. We used to get the actual books. Anyway, be able to show that you're paying tuition and you're actually maintaining F1 status. Finally, it is possible sometimes to go from whatever, let's say you're not selected for the H-1B lottery. It is possible, depending on your situation, to go from whatever your current situation is straight to the green card. It's not possible for everyone, especially for individuals born in India, because of the per country cutoff, the per country limitation. It's not possible for everyone, but I've had a number of clients who have been able to do that. And you should consider, if you're considering that, you should look at all the possibilities. Do you qualify for the EB1A classification? Is that a possibility? Depending on your country of birth or your spouse's country of birth, do you qualify for a national interest waiver that you could self-sponsor? Or is your employer able to start the process? Or believe it or not, multiple times I've had, and I'll look at these questions in just a minute. Multiple times I've had clients not selected in the H-1B lottery. We're going through all these options and they mention, oh yeah, well, I'm living with my significant other and we plan to get married. Would that be helpful? If they're a US citizen, that absolutely would be helpful. So sometimes people want to get the H on their own, or go through the immigration journey on their own merits, and that's totally fine. I respect that. But sometimes, if you're willing to, if you're getting married anyway, and if you're willing to go that route, it'll get you to the same place that you want to be, which is, for a lot of people, not always, not everybody, but for a lot of people, is the green card. Before I look at these questions, there are set, like I said, when I talk to individuals about these options, I go through the alphabet, literally, because there are other options as well. But these are the main ones that people use. I have a direct message question that I'll get to later. Can you pursue a different course like MBA and Day 1 CPT while your F1 master's was in computer science? The answer is yes. The CPT, the opportunity that you have on CPT has to be related to what it is that you're studying now. So if you're studying and if you're working on an MBA, for example, and you have Day 1 CPT, the opportunity that you have, the externship, for example, has to be related to that field of study, to the MBA field of study, even if previously you had a degree in computer science. All right, this is one that I believe you all want to hear a lot about, the green card outside of the EB2 or EB3 classification. So EB2 or EB3 is the most traditionally used, it's the most common, I would say, approach to the employment-based green card process. That involves the perm labor certification. I'm sure a lot of you are familiar with the fun that is and the long time that it takes. Then the employer files an I-140 petition, and then eventually you're able to file the I-485. Just as, for anyone who doesn't know this, just as a, I'm gonna bring myself up to the group chat here. Just for anyone who doesn't know, the reason that so many people are interested in this, there's a limited number of new employment-based green cards available every year. That limit is, does anyone know? The number of employment-based green cards available every year. Put your guesses in the chat. Okay, while you're putting your answers into the chat, I want to see what your answers are here. Here we go, 300,000. Anyone else? Any other guesses? While you're putting your guesses into the chat, I will tell you that the reason that there is such a long line for people born in certain countries is the statute. The rule says that no country can take more than 7% of the overall allocation of green cards. There are so many foreign nationals who would like to immigrate, meaning would like to have a green card, from China, India, Mexico, and the Philippines, that they have their own cutoff dates. So if you look at the visa bulletin, you will see a table, and there'll be a column for the rest of the world, and then a column for these other countries, China, India, Mexico, and the Philippines. That's because they would, if they didn't have their own cutoff dates, their own priority dates, they would exceed the 7% mark. So we have several guesses here: 300,000, 140, 200,000, 200,000. Krishnan is the winner at 140,000. the 140,000 green cards available, employment-based green cards available every year, and that includes spouses and children, so they get used up like that. So there's so many people who want a green card that there's a virtual line of people waiting for the green card. Your place in line is determined by your priority date, the country of birth, and the visa classification that you fall into. When I say visa classification in this context, I mean the employment-based green card visa classification. I'm not talking about whether you're on H or L or O or TN or whatever it is. I'm talking about the employment-based green card classification. So if you look at the Visa Bulletin is a document that's published once a month by the Department of State, and it tells us more or less where people, very vaguely, more or less, when a green card might be available for your particular category. When I say your category, I'm talking about your country of birth and your employment-based category. In general, there's a huge huge backlog of people basically waiting for a green card to become available for the EB2 and EB3 classifications, especially for India. Right now, there's a shorter backlog, but a backlog, albeit for everyone, including the rest of the world, when typically there's not. But for India, it's years and years and years. And there are different ways to calculate that. Nobody knows exactly how long it's going to take, but some of the classifications are not encouraging. A lot of them are not, but some of them are just not at all encouraging. So there's lots of interest. I say all of that to explain why there's so much interest in these other classifications, these alternatives. How can you avoid that EB2 or EB3 classification? The first option is the EB1A classification. The EB1A classification is for foreign nationals of extraordinary ability. So like I said, what I was saying about the O1 a few minutes ago applies to the EB1 as well. The regulatory criterion are different. There are 10 for 10, there's a list of 10 criteria for the EB1A, and you have to meet at least 3 of them, whereas there's 6 for the O1. But they're similar. So it's for individuals in any number of fields. It can be in science, arts, education, business, sports. So if we have any sports, professional, if you've won an Olympic gold, then be sure to apply for the EB1A. But it can, I've had an individual who works in pharmaceutical development apply for the EB1A and be approved. So it can apply to different industries as well. I go into a lot more detail on this in the chat that I had with this individual named Praneet that is on the YouTube, on his YouTube channel. And like I said, we'll have a QR code at the end, and we'll make sure and send everybody the recording of this, and there'll be a chance for you to have the slides as well, so you have access to that. But the criteria are pretty stringent. It's not easy to have it approved. It's definitely not for everyone, but it is for some people. So it's definitely worth at least considering and looking into if you can show that you're in the top part of your field, very top of your field. The other EB1 classification is EB1B, outstanding researcher or professor. That also falls into the EB1 category, and it applies to, as the name implies, researchers and professors. Again, you have to show that you're at the top of your field, and you have to show that you are a researcher, which means it's not limited to universities. Obviously, professor refers to a professor at a university. But the researcher can be somebody who works at a private organization. So again, I've had individuals in pharmaceutical development and other types of industries as well apply as an EB1 researcher, and that's a possibility. EB1C, I often have individuals ask me, hey, I'm an executive or a manager at my company, can't I qualify for the EB1C? The answer is it depends, traditional lawyer's answer. But the reason that I think this is confusing is because of the name, right? It says multinational executive or manager. So if you work for a company that's multinational and you're executive or manager, you should qualify, right? The answer is not so fast. You have to show that you have worked overseas at a entity overseas that's related to the US entity. That's the multinational aspect. in an executive or managerial position. So it's very similar. The criteria are very similar to the EB1, to the L criteria in terms of the corporate relationship that has to exist, and then the requirement that you work for at least one out of the past 3 years, at least before you came to the US, in a managerial position. So it's not for everybody, unfortunately, who works in an executive or managerial position. I wish. The other option, and I don't handle EB5s, just as a disclaimer, but the other option is the EB5 investment option. And we'll talk a little bit about this at the section about entrepreneurs as well. The EB5 is for individuals who invest in the United States. The investment amounts right now are $800,000. You have to invest at least $800,000 for individuals in the targeted employment areas, which is areas of kind of traditionally lower employment, or 1,050,000. So it's a significant amount of investment. Like I said, I don't handle those, but I can refer you out if that's something you're interested in looking into. So options for entrepreneurs. Before I go there, does anybody have questions about the EB1? I know this was one that a lot of people were interested in. Does anybody have questions about alternatives to the EB2 or EB3 classifications? Another option, of course, we're not talking a lot about the family-based options here, but that is something that I see a lot, even for individuals, or especially for individuals who are here on H or L. You know, they're working professionals here in the United States, and they get married to US citizens or sometimes permanent residents here in the United States. So that's an option as well. If you have questions about EB2 or EB3, let me know. We can always come back to it. So options for entrepreneurs. One of the amazing things about the Sumner, there's a question from Sumner, investment-based, how does the amount calculated? I'm going to leave that to the individuals who handle EB5. That gets into a little bit more detail than we're going to get tonight. But one of the things that I love about foreign nationals who come to the United States is that you all are so innovative. I say you all because my ancestors came, 500 years, not 500, 400 years ago. But innovative, and can't remember the percentage, but there's statistics out there that indicate the percentage of US companies that are owned by foreign nationals, that were started by foreign nationals, and it's absolutely amazing. So I am all for entrepreneurs. I'm all for foreign national entrepreneurs, and there are different ways to go about that. Thinking about the letter-based opportunities here, the letter-based visas, there's the E2. The E2 is not available. It's based on treaty, and we don't have a treaty with India. So it's not a possibility for individuals who are Indian unless you also have another nationality. So if you have another nationality that does qualify for the E2, absolutely. But the E2 is kind of the traditional investment visa. There's no specific amount that you have to invest for the E2. You can start a business or you can purchase an existing business, and we do handle E2s, unlike EB5s. But there is no specific amount that you have to invest. It depends on the overall cost of starting up the business. And there's kind of a sliding scale that they apply, the Department of State and USCIS apply, but that is a possibility. The L can be a visa for entrepreneurs. So in order to qualify for the L, there has to be an existing entity overseas. You can't just come to the US on an L and start a business out of thin air. You can for the E2, absolutely, but not for the L. For the L, there has to be an existing operating business overseas. And then you have to come to the United States to start an entity that is related to that overseas entity that will continue running. So it's not impossible to do, but it is USCIS and Department of State. But USCIS will look at the size of the company overseas. It's really, really hard to do, like next to impossible, if the company overseas is small. When I say small, I mean there's no magic number, but if the company overseas is like, 2, 5 people, maybe even 10 people, it's going to be really, really hard to have that approved. I've done it before where the overseas entity is 50 people, 100 people, and the entity here in the US is 20, 25. And I'm not saying it can't be done with fewer numbers of people, but it's really, really difficult. It's not designed to be kind of a startup type entity, though it can be. You can start a new office here. So L is a possibility. EB5 we talked about just a minute ago, and H1B is also a possibility. A lot of people don't think about the H1B in terms of entrepreneurs. Yes, Canadians are allowed for the E2. Canadians are also allowed for TNs. Don't let me forget to talk about that in just a minute. H1B, yes, you absolutely can file for an H1B for your own company. The trick is, number one, you're still subject to the H1B lottery, although you could do an H1B transfer to your own company. And number two, there has to be a board of directors or some group of people or persons that could terminate your employment, which is not a fun idea. I think I'm an entrepreneur. I don't think that's a great, thing for somebody who's starting their own business, but it is, it's not uncommon for a company to have a board of directors. So there has to be some way for you to actually be terminated from the position, but it is possible for you to self-sponsor an H1B. Somebody asked a minute ago, for E2 treaty, are Canadians allowed? Yes, the answer is yes. Canada is E2 eligible. So if you have, let's say that you were born in Canada or have Canadian citizenship, that's great. But also, like I said a minute ago, let's say that you were born in India, you have, and then you obtain Canadian citizenship, you would still qualify for the E2 visa. You have to be a citizen, not a permanent resident, but you could qualify for the E2 that way if you have Canadian citizenship, regardless of where you were born. The TN could also be a possibility if you're Canadian or Mexican for entrepreneurs if you come as a management consultant. Otherwise, you have to be an employee of the company in general. All right, visa stamping in the United States. I'm surprised not more people said that they were interested in this on our little poll, but I know for a fact that people are interested in this because I get questions almost once a week about the possibility of visa stamping in the United States. The answer is, I don't know if anybody remembers that visa stamping, this was before I started practicing, but visa stamping in the United States, meaning having your passport stamped with a visa, whether it's H or L or J or whatever it is, was a thing before 9/11. And then it became no longer a thing. And you have to get, right now, as of the way things are right now, you have to have your visa stamped outside at a US consulate outside of the United States. It is not possible right now to have your visa stamped in the United States. The Department of State is very excited that they are going to implement a pilot program to allow individuals to have their H or L visa stamped in the United States. And I think this is amazing. I don't have to tell you all as foreign nationals who are here in the United States how amazing that would be to not have to go to a US consulate outside of the United States. They say, so I have heard about this program from different places. But I went to the American Immigration Lawyers Association annual conference this past June and went to the Department of State open forum. And they all love to toot their own horns and talk about how wonderful they are. Okay. But they were very excited about this and they were adamant that they were going to do this and that it was going to start at the end of this year, at least the pilot program. That could change. No, but nothing is written in stone. But yes, Barbara, I agree. That is awesome news. We don't know exactly what the pilot program, what the rules of the pilot program are going to be or how you're going to be eligible for the pilot program. But I would imagine when this is rolled out larger scale, that it will probably be limited to certain visa classifications. H and L, probably they would start with and then maybe expand to other visa classifications. And then there'll probably be rules regarding the stamping. Like, for example, maybe it's only available for renewals for the same classification, rather than a change of status type situation, or things along those lines. Probably rules along the lines of the rules that are in place right now for the interview waiver program. We will make sure to spread the word far and wide when we have any additional information about that program. But right now, you still have to leave the United States and have the visa stamped. So how soon will it be expanded? We don't know. That's a wonderful question, and I wish I had the answer to that. Like I said, the only information that I have is as of June, the Department of State officials at the AILA conference were saying before the end of the year. It's September, and we haven't heard anything else about it, so I have my doubts. But I hope that it will be sooner rather than later, because I know that would be a tremendous advantage for everyone in the United States and those who are eligible to have the visa stamped here. So other visa stamping tips. One is the interview waiver program you're probably familiar with, meaning if you're here on a temporary visa, meaning the Department of State has waived the interview requirement for visa stamping if you meet certain conditions. My experience, they started this over COVID because consulates were closed and they were backlogged and all, it was a hot mess. So they started it over COVID. As of December of 2022, they said, okay, we're going to extend this program through December 31st, 2023. We have not heard anything else about it being extended. I hope it will be, because it makes sense. If a person doesn't have a criminal background, if they don't have an immigration violation, why not just have the stamping without the interview? I don't see the need for the interview, but I'm not in charge. Department of State, obviously. Yes, I'm sure. Sundar asked, do we have to pay visa fee even if we are stamping with extension? Yes, as of right now, absolutely. And I'm sure you'll have to pay a fee to Department of State in the US if they do it that way. Anyway, interview waiver program, we don't know if that's going to be extended beyond December of this year or not, but we'll keep everyone posted on that as well. Our experience with the interview waiver program has been, it's hit or miss. A person sometimes you have to apply for that when you're in in country. So I know at least in Chile and other countries as well, you can't even apply until you're actually there. Ireland as well. And then and India. And then it takes forever. Even if you have the waiver of the interview, it still can take weeks and weeks and weeks, if not longer. So that's our second tip here, is to plan ahead. If you are planning to travel and you know that you need to have your visa stamped, plan ahead. If you have to have an interview, make sure that you schedule that interview as far ahead as you can. Consulates are still backlogged because of COVID, and then just in general because they're busy. I'll leave it at that. So it can take a while to have your visa stamped. So plan to make your appointment or to submit your passport for stamping as soon as you can. Plan to have that done on the front end of your trip so that if there is a delay, if it takes several weeks or longer to have your visa stamped, hopefully that won't delay your return to the US. And then consider if you can travel on advanced parole. I have numerous clients now, dozens, who have submitted the I-485 application. They were able to do that in October 2020. And they are maintaining H-1B status at my recommendation, and because I recommend that you maintain the underlying non-immigrant status as long as you can, but they have a valid advanced parole. So talk to an immigration attorney, make sure that it's appropriate for your situation. But I've had numerous clients return on the advanced parole and then go ahead and file the H-1B extension when it's time to do that. And that is permissible. There's a memo out there that allows for this. That can be a great way to have the best of both, to not have to worry about visa stamping, but then also to maintain H-1B status in case something happens with the I-485. Options for aging parents. So I don't know about any of you, but I have aging parents. My husband has aging parents, and it's hard even if they're in country. My parents are here in town. My husband's parents are in a different state 4 hours away, and it's a lot. I cannot imagine having parents who are aging and needing more and more help outside of the United States. So my heart goes out to anybody who's in that situation. I know it's hard. There are several different options, but not ideal options for individuals, and they can be not aging. I guess everybody's aging, but my point is they don't have to need medical assistance for these options to apply. But the options are that they can apply for a tourist visa. So they can apply for a B1, B2 to come visit periodically. The visitor's visa, you have to have it approved. So that means you have to have the visa interview, or at least have the visa stamped. Fortunately, for a lot of countries, including India, the stamp is valid for 10 years and it's valid for multiple entries. That's not true for every country. Depends on the reciprocity, but that's a possibility. The B1, B2, the visitor's visa is designed for situations that where the parents or whoever it is that has the visa is coming to visit temporarily. So they're coming to visit for a few months and then go back home. So it's not an ideal situation if a person wants to spend half their time here in the US and then half their time in their home country. But there's not really a solution for that. And you'll see why when I talk about these other two options. The other option is to sponsor your parents for permanent residence. So it's kind of one extreme or the other. Sponsor them to have them live here in the United States permanently, long term, or have them apply for a tourist visa, hope that it's approved, and have them visit temporarily. And you can switch from one to the other. You can have them come, for let's say a few months at a time on the visitor's visa, and then down the road apply for a green card. If you decide to apply for a green card for your parents, first of all, you have to be a US citizen to sponsor them. You cannot be a permanent resident, and unfortunately you can't be, obviously on a temporary visa classification yourself. So you could file the I-130 and consular processing. That's what that CP stands for. That means that you sponsor your parents for permanent residence while they are overseas, and you wait out that whole process with them overseas. They could potentially enter the US on a visitor's visa while they're waiting it out. But make sure that you talk to me or another qualified immigration attorney before you do that to talk about any risks and challenges with that. That process right now is taking at least 2 years, probably closer to 3 years from the time you start to the time that they have the visas issued and they're able to enter the United States. When I say visa there, I mean immigrant visa, long-term visa. The other option is the I-130 and the I-485. That is available for individuals who are here in the United States. Let's say that mom and dad enter the United States on a tourist visa and you have a conversation with them and they decide they want to stay long-term. Then you can sponsor them while they're here in the United States for permanent residence. They do have to stay in the United States until they have the advanced parole, the travel document approved, which could be several months. So that's something to keep in mind, but it is a possibility. With permanent residence, I said that it's one extreme or the other, because with the visitor's visa, they can only stay for up to 180 days. They'll be admitted for up to 180 days total. And the more often they enter and the longer they stay, the more likely that they're going to have problems at the port of entry. It's not guaranteed, of course, but the officers at the port of entry like to ask questions. In case you haven't noticed, they've asked me questions and I'm a native born US citizen. The other option, permanent residence, means that they have to reside in the United States. That doesn't mean they can't leave the United States and they can't travel, but you have to be careful about where they spend the majority of their time, where their center of life is. So if they're spending more time outside of the United States than they are in the United States, that could be cause for concern. And officers at the port of entry may be saying, okay, are you really maintaining permanent residence? You may have heard of a rule. We have a couple of questions here. You may have heard of a rule that if you have a green card, you have to spend at least 6 months in the United States. That's not a thing. I think that comes from a technicality that I won't get into right now, but that's not a rule. The rule is if you spend more than a year outside the United States, while you have the green card, then your green card is considered abandoned. And when you try to re-enter the United States, you're probably going to have problems. Things have gotten a bit more lax with COVID, but you're probably going to have problems. You may be referred to the immigration judge to begin deportation proceedings, so it's risky. Don't spend more than a year outside the United States. But there's an in-between. So I'm kind of rambling here, but my point is that there is no black and white rule as to how much time you have to stay in the United States versus outside of the United States. But before you file for permanent residence for your parents, have a conversation with them and with any other relevant family members to talk about how much time are mom and dad actually going to spend here versus outside of the United States, and then talk to me or another qualified immigration lawyer about what the best option for your parent might be. Marthy asks, is there any sponsorship possible with a temporary visa? Yes, but there's not like a grandparent visa. I wish that there was. And I think that that's a thing in other countries because multiple people have asked me that about the grandparent visa. And I really wish that was a thing. So we would be talking about sponsoring them for an L or an H-1B or an O and having them work in the US. A rule asks for B2 after a 6-month stay in the US. Is there any cooling period for them to go out and come back? That's a great question. The answer is no, that there's not any rule. There's no written rule. In general, the longer you stay in the United States on a B1, B2, and or the more often that you come, the higher the chance that you're going to be scrutinized at the port of entry, meaning be asked questions about your intentions at the port of entry. It's not there's nothing that says you can't enter the United States more than X number of times per year. And there's nothing that says once you're here for 6 months, you have to stay outside the United States for X period of time. It's all about how it looks, how it comes off. And honestly, it depends on the officer at the port of entry and what they notice and or want to ask about. What would happen to the I-130 if they enter in B1, B2 after applying for the I-130? That's a great question, Gowrie. Maybe nothing. When we have that situation for clients where we have filed the I-130 petition, we give the clients a letter, the clients who are traveling on the B1, B2, a letter for them to take. I call it a back pocket letter. I say, don't show this unless you need to. But we send them with a letter from me explaining that our clients have applied for have submitted the I-130. They've elected to do consular processing. They are here for a short visit, and it can be, several months, but they're here for a temporary visit, and they understand the risks of staying and that they can't stay in the United States. They're not legally permitted to stay in the United States. They have a return ticket, and they're going to return home to pursue consular processing. Knock on wood, I don't even want to say it, but that letter so far has been sufficient. But it is possible that the risk is, the reason I give clients that letter is because the risk is that if you have the I-130 petition pending or approved, you're showing that you have what's called immigrant intent, meaning you plan to come to the United States to live permanently, but you're entering on a temporary visa, which is temporary. So the two are not aligned, let's say, but it is possible. And I've had multiple clients do it. All right. We are to the question and answer period, and I am happy to answer questions. We have some that have come through on this. Let's see. I'm just going to bring this over here that have come through on the chat. If you have questions that you want to put in the chat, go for it, and I'll try to address those. If you have a question that you want to ask yourself, feel free to unmute yourself and ask. I will say in general, it's easier for me to read questions than to listen, especially if they're detailed. If you can't unmute yourself, let me know. Just put it in the chat. I think that you're able to, but if you can't, let me know. Sundar asks, can you explain little on visiting Canada, Mexico, and automatic visa revalid? He says realization, hearing a lot of differences on that. Yes, it's called automatic visa revalidation. That means that your visa is temporarily revalidated. So there's certain requirements that you have to meet. You have to be traveling to Canada, Mexico, or an adjacent island. And the adjacent island is actually defined in the regulations. I can't list all of them, can't remember all of them to list right now, but basically a number of the Caribbean islands. You have to be traveling for 30 days or less. You have to have a valid petition, underlying petition. So this applies to different visa classifications, including H and L, but also F1, for example. You cannot apply for a visa, new visa, while you're outside of the United States and use automatic visa revalidation. So you couldn't go to Canada, for example, to apply for a new visa, and that is possible. You can do third country processing if the consulate will accept you. that you can't apply for the visa, have it rejected, or get a 221G and it's delayed, and then come back in. You just go visit, do whatever you're going to do for less than 30 days, and then re-enter the United States, even though your visa has expired. It's pretty cool. And we've had a number of clients do that, and it's been fine. Raj, if we give a birth certificate recently, will it be okay, or still do we need someone to get some affidavit from someone? Yeah, so I think you're asking about, I don't know, but I think that you're asking about Indian birth certificates. I will say this, and I can't, like I said, I can't give legal advice here, but the reciprocity table, there's something called the reciprocity table that is published by the Department of State, and I'll put a link in the chat here. While I'm doing that, has anyone put in the comments if you've ever heard of the reciprocity table? No one cares about the reciprocity table. Okay, I'm putting in the chat the link to the reciprocity table. So the reciprocity table is published by Department of State. If you look up your country, so for example, if you were born in India, then you look up your country and then you look at the link for birth certificates, and it will tell you the exact document that you need. Indian birth certificates, I know from experience, have been challenging. My experience is you have to have a birth certificate if you were born in India if you were born after April 1st, 1970, you have to have a birth certificate. If for some reason you cannot get one, you have to have a certificate of non-availability, and there's specific information about that on the visa reciprocity table here for India, but you have to have the certificate of non-availability, and I recommend 2 affidavits from people that have firsthand knowledge of your birth. So my recommendation is, number 1, check the reciprocity table, and then if you can't get it, you have to have that certificate of non-availability. That's been my experience with clients. Let's see. Sumner asked if you can apply for visa revalidation before you leave. No, the answer is no. And it's not really even anything that you apply for. You just go. I know it's scary, but you just go. You check beforehand, talk with an immigration attorney, make sure you meet the requirements, but you go and then re-enter. And assuming you meet the requirements, you don't apply except to talk to the officer at the port of entry. Can earlier L1A experience be used to apply for EB1 when currently in H1B? The answer is yes. So I think that Stanley here is asking if you can apply for the EB1C classification, which is for multinational executives or managers. The answer is yes. You don't have to hold L1A status to be able to apply for the EB1C. Can one travel to home country, India, while H4 application is in progress and get approval stamping in India? Yes, you can do that. You would just have to show, the person applying for the H4 visa would just have to show the H1B spouse's valid H1B approval, the I-797, to be able to get the visa. If Rajashekar asks, if the birth certificate is unavailable, what alternative documents can be used? Why might an embassy issued birth certificate not be considered valid for immigration purposes? That's another one to look at the reciprocity table and see exactly what's required for your country. If it's India, they list alternative documents. It says if an individual is born after April 1st, 1970, you have to obtain a certificate of non-availability. In addition, submit these documents, and you can look at the website, but it's school leaving certificates, matriculation certificate, and then it mentions affidavits. Affidavits is what we typically use. Okay, Kaif, I know, asked this question earlier. His H-1B is going to expire in February 2024. H is with a nonprofit organization. They haven't filed my I-140 in perm. What are options available to keep my status active? Do I need to go to CPT again? I filed H-1B lottery through this, and this year through another employer. Can I file petition with them? So if you are, I'm assuming that you're running out of time in H-1B status, meaning your 6th year is going to expire in February 2024. That's a difficult situation if you haven't filed your I-140 in perm. I don't know if they have filed the perm at all, if there's any hope that you would be able to file the I-140 petition before and have it approved before February 2024. But if at all possible, I absolutely would do that. Otherwise, you're looking at changing status to another visa classification like F1, for example, or leaving the US for at least a year and then coming back. Without I-140 approval, H-4 dependents can apply for EAD or other possibilities to get a work permit. Yes, there's something called, it's not extenuating circumstances, but something like that. This is Kumaravel. I actually did, I think I did a LinkedIn post about that. No, I did a blog post. I did a blog post about that. Just a minute. So if you go to my website, sumnerimmigration.com, compelling circumstances, that's what it's called. I'll put the link here. So I actually did a blog post about that, and I'm going to put it for everyone. You messaged me directly, but I'm going to put it for everyone. Raja Shaker says, I do not have a surname on my school leaving certificate. Then I would use a different document instead, like a affidavit of birth. But I will say it's very common to have different name spellings on different documents for people born in all different countries. And generally, USCIS and Department of State will go by the spelling that you have on your passport, and then you'll just need to explain discrepancies on other documents. Divya asks, is it possible to revoke H-4 application quickly in case a parallel H-1B transfer completes sooner than H-4? So it sounds like this person has or potentially will have an H-4 in process and an H-1B. That's a tricky situation. Yes, it is possible to ask USCIS to withdraw, because the reason I think that you're asking, Divya, just so everybody knows, is there's a rule that the most recently issued I-94 is the one that governs. So if the H-1B is approved and then subsequently the H-4 is approved, then the person's status is H-4, even though they want to be in H-1B. So the question is, can you revoke the H-4 application? Yes, you can ask USCIS to. I have done that before in H-1B petitions that we file. I've said, hey, this person has an H-4 pending. Please either approve that and then approve the H-1B or revoke the H-4. Kumar, I think that somebody raised their hand, but now I don't see here we go. But now I don't know how to. Recognized hand gesture. Okay, Kumar, if you can put your message and your question in the chat, I think that would be helpful. Unable to mute off. Okay, just a minute. Okay, now see, Kumar, if you can unmute.
Yeah, thank you. That's
Sure.
your name. Can you hear me? Yeah.
Yes.
Thank you for doing this. Really appreciate it.
You're welcome.
And thank you to Tamizh team and the FETNA. I live in Bay Area, but this is for one of the community member I'm asking. I think the spouse is, if one of the spouse, the husband is divorced, the spouse visa, if she is in visa, what happened in that condition, that situation? So what is the possibilities he can apply for any other visa? What is the Is there any duration? If you could give that one help, or if you need to reach separately, we can reach out to you also.
Yes, I think it would be best for them to reach out to me directly.
Okay, I will let them to reach out
Great.
to you.
Thank you.
Yeah, thank you.
So I'm going to wrap this up in just a minute. I'll take a couple other questions, but before I take a couple other questions and then wrap up, I want to make sure that individuals know how to reach out to me. So this is the YouTube channel that I mentioned a few minutes ago, and we'll make sure to send this information to a recording to anybody who registered online. But I also want to put up a quick poll for anyone who wants just a minute. Okay, if you want a PDF of the slides, if you can put your information in here and we will email the slides to you. If you registered, you don't need to, we'll go ahead and send them to you. But if you didn't register, we don't have your email address. And then other ways to contact me are through LinkedIn, my individual LinkedIn. I post regularly there updates, and I would love to connect with you on LinkedIn. We also have other social media channels here. We have a YouTube channel just a general YouTube channel, and then we have a library within there that is the Sumner School of Business Immigration Basics. So be sure to check us out there. If you would like to consult us for individual questions that you may have, or if you own a company and you'd like to talk to us about sponsorship, sponsoring individuals on the H or the green card, feel free to reach out to us as well. Our website is available in these slides and is available in this QR code as well. So I hope that you will connect with us. And like I said, put your information in the poll if you didn't register online and if you'd like to get this information. I'll take a few more questions and then I'll wrap up around 9:20, which is I think 8:20 Tennessee time. Let's do this. This is a direct message. My wife completed the MS and STEM course on August 15th. Pregnant now, would you recommend time for OPT fine or going to J1? Sorry, going J2 as I'm on J1. That's something that we could talk about in a consultation. I can't give legal advice here.
Hello.
Yes.
Yeah, hi. Actually, I have a question. Like, I have filed a H1B to another employer. So, will I get 3 years if I apply that H1B?
If you have 3 years left, yes. So there's a limit of 6 years in H1B status, but when you file an H1B transfer, you can request up to 3 years for, basically you can request an extension at the same time.
No, actually, this is my last year, H1B.
Okay, it's your last, so whatever amount of time, and do you have an I-140 petition approved?
No.
Okay, then if you do not have an I-140 petition approved, and has an employer filed a green card for a perm for you ever?
No.
Okay.
I think other employer can file the I-140.
Okay, but no one has filed a perm for you?
No.
Okay. In that case, you would have whatever time you have left in the 6 years, you would have for the new employer that you transfer to. But you probably will probably run out of time in your 6 years of H-1B, even if they start the perm process for you immediately. So you may have to leave the US for a while, or you may have to change status to another visa classification while you're waiting for the I-140 petition to become approved.
Oh, okay. All right. Thank you.
Yeah, I'm sorry. That's a tough situation.
Yeah.
All right, I'll take one more question. For my sister, this is a direct message here. For my sister who is UK citizen, can she apply E2 visa for her husband and 2 daughter all are UK citizens but born in India. Yes, if you're a UK citizen, if you're a UK citizen, absolutely, they can apply. If a person is a UK citizen, they can apply for the E2 visa regardless of where they were born. Well, I want to thank everyone for attending. This was a lot of fun to connect with you all. I hope that you will contact us for a consultation if you have more questions that we haven't been able to address here, or if there's anything that we can help with now or in the future. And in the meantime, please do connect with me on LinkedIn. I'm happy to do that. And like I said, I try to post frequently there information like this to share with the community. It's been such a pleasure speaking with all of you today. And it's a pleasure and an honor to help foreign nationals navigate the very complex and challenging U.S. immigration system. I hope you all
Thank you so much, Emily.
You're
this
welcome.
This is awesome. And anytime you plan to come down here to Nashville, hit me up. We'll go out for lunch or dinner.
Absolutely.
I'll be happy to chauffeur you around.
Absolutely. I love that. I'll definitely do that. Well, thank you so much for organizing.
Thank you.
All right. Have a great night.
Bye.
Bye.